Welcome back. Today's topic is kinds of companies on the basis of members. There are three kinds of companies on the basis of members mentioned under Section 3 subsection 1. Those are private company, public company, and one-person company. Number 1, private company, means a company, as defined by Section 268, means a company having a minimum paid-up share capital as may be prescribed and by its articles of association. 2. Restricts the right of the members of the company to transfer its shares. 3. Except in case of one-person company, limits the number of its members to 200, excluding members who are over in the employment of the company. It may also be noted that if 2 or more persons hold shares jointly, such joint shareholders shall be treated as single member. 4. Prohibits any invitation to the public to subscribe for any securities of the company. Name of a private company must end with words private limited. Section 149(1) further lays down that a private company shall have a minimum number of 2 directors. The only 2 members may also be the 2 directors of the private company. Next, conversion of a private company into a public company. A private company may convert into a public company by following the provisions of Section 14 of the Companies Act, 2013. The provisions are: A. Passing of a special resolution to alter its articles of association to exclude the restrictions of private company, viz. transferability of shares, maximum number of members and prohibition on inviting the public for subscription of securities. B. Filing of altered articles of association along with a copy of special resolution in the prescribed form, INC 27, to the concerned registrar of companies within 15 days of passing of resolution. The company shall cease to be a private company as from the date of alteration of articles of association. Second, public company. According to Section 271 of the Companies Act, 2013, public company means a company which is not a private company. It can invite the public to subscribe its shares and does not have any restriction on the transfer of shares. The minimum number of persons required to form a company is 7 and there is no maximum limit. Subsidiary of a public company, whether constituted as a private company or public company, shall be regarded as public company. Section 149(1) further lays down that a public company shall have a minimum number of 3 directors. Next, conversion of a public company into a private company. A public company may convert into a private company by following the provisions of Section 14 of the Companies Act, 2013. The provisions are: A. Passing of a special resolution to alter its articles of association to include the restrictions of private company, viz. transferability of shares, maximum number of members and invitation to the public for subscription of securities. B. Approval of the tribunal, not yet enforced as the tribunal has not yet been constituted, till that the approval from the central government is to be taken. C. Filing of a copy of order of the tribunal approval, copy of the altered articles of association along with a copy of special resolution in the prescribed form to the concerned registrar of companies within 15 days of approval from the tribunal. The company shall become a private company from the date of approval from the tribunal. Third, one-person company. Section 262 of the Companies Act, 2013 defines that person company means a company which has only one person as a member. One-person company is required to identify in its name in bracket as one-person company after its name. As per Section 3, a one-person company, OPC, may be formed for any lawful purpose by one person, as a private company, by subscribing his name to a memorandum of association and complying with the requirements of the Act in respect of registration. Section 3(1) further provides that the memorandum of association of one-person company shall indicate the name of the other person who shall become the member of the company in the event of subscriber's death or his incapacity to contract due to insanity, etc. A written consent of such person would be required to be filed with the registrar of companies at the time of incorporation along with memorandum and articles. Any change in the name of the nominee shall not be deemed to be a change in the memorandum of the company.